Ladies and gentlemen, I'd like to welcome you to the latest Greens List seminar. My name's Stephen Sharpley and I'll be chairing the seminar. As I'm sure you're aware, the subject matter is the new GST withholding regime that's going to apply to certain sales of residential property. I'm not going to steal the thunder of our excellent speakers by saying much more about it, other than it's an interesting matter because it's another provision that's at the intersection of tax law and property law, and so naturally we have one speaker from each field to deal with the matter. It's arisen out of a concern by the government. It's not a new tax as such, it's a new mechanism to collect an existing tax that's arisen out of a concern by the government that a large amount of revenue is being avoided in the industry. We have two speakers tonight. Michael Bearman, our first speaker, is a very experienced tax barrister, appears in federal litigation and in state as well. Also has a very active practice in general commercial law and equity and trusts, and he's prepared one of the two papers, and he'll be speaking first. Our second speaker is David Lloyd, and he's a it's for emphasis, and he's a very experienced property law barrister, the author of some learned tomes. Perhaps more relevantly, or most directly relevantly, he's also one of the two authors of the standard RIV-LIV land sale of land contracts since 2008, and he's one of the two authors of the general condition that has been drafted to deal with this new legislation. So he's uniquely equipped to speak on this topic and answer your questions. So without further ado, I'll turn over to Michael Bearman, who will speak first. Thank you.
Thanks, Stephen. Is that working? GST withholding, I should say that I was told to start with a joke, and I struggled to find a joke about GST, but I did get asked, well, what's the difference between tax accountants and tax lawyers, and the answer is that tax accountants know that they're boring. And I apologise, it's a subject matter, but anyway. The other difference between tax accountants and tax lawyers and property lawyers is that most accountants know how to use PowerPoint, and you'll see from our extraordinary audio-visual aids that we've mastered it. The GST Act was very carefully crafted when it was brought in 2000. There was a great deal of consultation, and there were a great number of ways that the legislation and the policy behind it could have been structured once it was decided that Australia needed a consumption tax, a broad-based consumption tax. And the mechanism that was chosen, which we all know and love, was to limit the tax to the suppliers of goods and services in a general way, rather than to tax the consumer as the recipient of the supply. And the various worldwide models were looked at, and one of the main reasons that model was chosen was because it limited the number of people, including companies, that had interaction between the community and the tax office. It limited the number of taxpayers, it limited the number of returns, and you still passed on the tax, so it still was a consumption tax. It was just an identifiable amount that was taxed on consumers, and the Act contains some basic thresholds for the people to whom it applies. You have to have an enterprise, so something carried on in the form of a business. You have to have, before it's mandatory, you have to have a turnover that's above a threshold of $75,000 a year, an annual turnover. Of course, you can opt in, and there are various other mechanisms in the Act to identify who the taxpayers are, and it combines with the ABN, the business number legislation that was brought in at the same time, so that the mechanism of tax invoices moving up and down the chain that most of us will be familiar with, to allow the collection of the tax as goods and services moved up and down through the supply chain and value was added to them, so they could eventually be passed on to a consumer. Now, I stress all this because, and in the paper I've gone a bit overboard on a revision of GST law, but I stress all this because this new amendment for GST withholding turns that underlying policy on its head. So let's just quickly look at the problem that's being suffered. We have real property. Now, real property is one of those types of assets that can move in and out of the GST net because it can be used for purposes that are part of an enterprise and cause it to be taxed, or it can be used for private and domestic purposes, main residence, beach houses, rental of residential property that's outside the GST net. Buildings can get knocked over, new buildings can be built, it comes back into the GST net. Of course, in 2000, one of the great concerns was how do we deal with all the land that's owned and is now going to form part of enterprises, and how do we bring it in? And so we have a system that was applied specifically to real property, which is the margin scheme system, where instead of tax being paid on, GST being paid on gross receipts and credits being given for gross outgoings, the government says, well, if both parties agree and the land qualifies, you can apply a scheme where the GST is only on the margin. And of course, being a tax on a net amount, it's almost always lower than the tax on the gross amount. So we've got this system of GST, which is our broad-based consumption tax. We're applying it to land, and we've identified that not all land, real property, is going to be subject to GST. And the question then was a policy question: which sales of land do you encompass in the GST? And the answer decided upon by Treasury at the time was that only new residential premises would be subject to GST, and not old premises. And the thinking was, of course, that if you're constructing new residential premises, you're probably carrying on an enterprise, you're a property developer of doing it, but if you're living in a home and you're selling your home, you're not engaged in an enterprise, so it should be outside the GST net. So the legislation defines what new residential premises are. They are premises that haven't previously been sold as residential premises. We carve out what's called commercial residential premises, which are hotels and motels and inns and the like. And of course, because tax lawyers are very good at getting around tax acts, we throw in everywhere long-term leases as tantamount to sales of property, of real property, and a long-term lease is defined as a lease of 50 years or more. The second category is you can have new residential premises if you substantially renovate a building. There's a whole lot of rulings about how substantial the renovation has to be before you turn an old building into new residential premises. And the third category is having built or contained a building, you build a building to replace a demolished building, and that creates new residential premises. Now, apparently, the property industry, or the property development industry, has been naughty. Tax Office identifies through phoenixing in the explanatory memorandum. It's quite a lot of money. They talk about $1.8 billion in several years, and I understand anecdotally that offshore vehicles are often used in this industry. And what happens is when you lodge your GST, some of you will know, you lodge your business activity statement containing the difference between your debits and your credits, and in my case quarterly, if you're a smaller taxpayer annually, for a large property developer probably monthly, and then 28 days after your tax period your tax falls due. And what's happening, of course, is in the period between the end of the tax period and the collection of the funds on the settlement of the sales and the due date for the GST, the company's either going into liquidation or people are disappearing, or both. And how much of it's evasion, how much of it's phoenixing, how much is fraud, we don't know and probably never will know. But it's enough of an issue that the government came up with a whole new regime to deal with that specific issue. And it's some regime. The first point is, contrary to everything else in GST law, this regime only applies to people who are not registered for GST. So, having carefully made a decision not to tax consumers, they're now going to apply the tax to consumers. And I mean, it's a silly policy because the last person who's going to know their obligation is the person to whom the Act doesn't apply. But that's the first point. Or alternatively, if you are registered like I am as a barrister, it applies to me for things that I'm doing not for a creditable purpose. So if I buy a house off the plan to live in, of course my registration as a barrister, as a business, has nothing to do with it. The next thing that you need to note is that the legislation redefines the definition of new residential premises that I've just taken you to, and it carves out the part of the definition that caused substantial renovations to be new residential premises. So there's now a distinction between substantial renovations for new residential premises in the ordinary GST provisions, and whether which is new residential premises, but for the purpose of these withholding provisions are going to come through, they've been carved out. They haven't carved out the category of things being built to replace demolished premises. So now there's a distinction between demolition and internal rebuilding, and it creates a bit of a mismatch that I think is going to cause some difficulty in application, but I would have thought only in narrow cases. The Act allows the Commissioner to exempt categories of land from these provisions if he wants. Now, how these provisions work is the legislation simply requires the non-registered consumer, who's the purchaser of this land, to pay money to the Commissioner, and the amount that's paid depends upon whether the margin scheme is applied to the development or not. And you'll recall that a margin scheme has to be elected in the contract or before settlement in the event between the parties. If the margin scheme doesn't apply, then the consumer has to pay 1/11 of the contract price to the Commissioner, or for family arrangement or something like that. There's no contract, then it's the price, which is the consideration of market value. And if the margin scheme does apply, then the legislation has just picked a number representative of the margin, which is 7%, and that has to be paid to the Commissioner, and there's provisions allowing the Commissioner to determine new rates to replace the 7%, but he's limited to the range of 7% to 9%, so it's not a huge range. I think the assumption is that it must always be less than 10% because you're only taxing the margin. There's the usual anti-avoidance provisions for sales between associates to uplift you to market value and the like. One of the questions I flagged in the paper is sales amongst associates that are wholesale sales. So say there's a large property developer owning greenfield site, and senior executives are granted an option or entitlement to acquire swathes of the subdivided property, which their related companies are then going to sell. Well, you've got a sale to an associate. The wholesale price will be less than the actual retail price for each block, and the whole system of greenfield site profit works on that. And the question then arises, when you're valuing the site for the purpose of the withholding, do you apply the wholesale price or the retail price? I don't know the answer, but you can see there's room for difficulty there when an amount equal to the relevant part, 10% or 7%, has to actually be paid on a day. The rules allow for apportionments if there's multiple purchases. Perhaps relevantly, joint purchasers are treated as single purchaser. So, as I read the legislation, it's assuming that the incoming purchaser is going to be registered as joint tenants. They're treated as a single purchaser. If you're coming in as tenants in common, the obligation goes in proportion to the ownership. Bearing in mind it's a note of obligation to pay the Commissioner. Now, how is the incoming purchaser, do you know what you've got to do, apart from the fact you've got a brilliant lawyer doing the conveyance? You need to know something about, you know the contract price, and you ought to know whether or not the margin scheme applies, so you know the amount. In addition, vendors are obliged to notify purchasers, and interestingly, the definition of the notification does not apply to new residential property to which these provisions apply. It applies to residential premises, which is effectively all residential premises, and the Act provides that you must not make a supply, sale or by long-term lease of residential premises or of potential residential land to another entity unless before making the supply you've given the other entity written notice stating whether the entity will be required to make a payment under section 14.250. Now, as I understand that, I might be wrong, but my understanding as I read that is in every conveyance where there's a vendor, there's now an obligation to make that statement, even though 99% of the sales won't have anything to do with this act at all, because you're selling residential property. I mean, it can't have been intended, and either the definition's wrong or I've misread it, but that's what it seems to say.
You're right.
And the difficulty with that, of course, is it's backed up by criminal sanction. It's an absolute liability offence not to do it. 100 points of penalty units, whatever that is these days, per offence. So it's a very unusual proposition. And when you give the notice, it contains the sort of thing that you'd expect. ABN, name of the person, whether it applies, the amount, and so on. The notification must be made. I think there was a difference between the draft legislation, the actual legislation. The notification must be made before the supply is made. Now, the supply is not going to be made until settlement, so presumably a vendor with all this critical information, the notification, is going to rock up at settlement and hand over a notice, which leaves the purchaser in a difficult position in preparing for settlement if there's non-compliance with these rules. I've noted also there's a defence of reasonable belief that the requirements don't apply to these criminal offences, but for some reason they've drafted that defence as only applicable to the information in the notice, not the notice itself. So you can't say I had a reasonable belief there would be no GST and not provide a notice if you're an ordinary vendor of commercial premises. It doesn't get you out of the criminal offence. Why they've done that, I have absolutely no idea. Now, the way that this is structured is it's intended to be a withholding tax. I'll put a question mark on that, but all the Act says is you, the purchaser, must pay, and then that's all in the Tax Administration Act, and then in the GST Act itself, the vendor is given a credit for the amount of paid by the purchaser in accordance with these rules. So I think the theory of the legislation is you've got land sold for 1.1 million, forget about stamp duty for the moment, you've rocked up to settlement, the purchaser zooms off electronic transfer to the Commissioner for $100,000, and you settle the contract by handing over $1 million to the vendor, and that would be how withholding tax works. And the problem with the legislation is that it doesn't say that. There's no statutory indemnity to the purchaser for the tax paid. There's some refund provisions, I'll come to those. There's no mandatory reduction in price, probably constitutional reasons for that. What's happened is that it's left to the contract between the purchaser and the vendor to determine this. And I can see, in the early days of this when people get it wrong, or even more so, particularly unscrupulous property developers not adopting Mr. Lloyd's wonderful standard terms, but preparing their own terms that deliberately obfuscate the issue. And when the purchaser says, but I've withheld or I've given the money to the Commissioner, says, well, hang on a second, there's nothing in the contract that provides for a reduction of the amount that has to be tendered on payment. You're in breach. Guess what? I want to get out of the contract. So it's just been left to the market, particularly the property development market, who will drive all of this and drive all the standard terms to deal with it. And I just find it a little bit odd because it's sort of an anti-consumer process. And what's happened is, in fact, in the whole of the thing, as I say in the paper, the whole thing is the risk has been shifted from the revenue to the consumer, which is an odd place to shift it. If you don't comply as a purchaser, the ordinary provisions of the Tax Administration Act impose a penalty equal to the amount you didn't pay. So how the Tax Administration Act works is that there's a division in Schedule 1 that's concerned with withholding amounts and other amounts payable to the Commissioner, and it applies to things like interest withholding to foreign companies, which is a final tax. It's concerned with royalties paid overseas. It's concerned with deductions of PAYG from wages earned by employees and the like. And they're all examples of circumstances where, when the amount is paid, the net amount is paid to the recipient, and there's a withholding. And you can understand in those circumstances that there's a section that says, well, if you don't pay, the Commissioner can penalise you 100% of the amount you didn't pay, because the penalty is going to stand in lieu of the Commissioner saying you failed to pay me the amount you would have paid me. Now, in this case, of course, there's no mechanism between the purchaser and the vendor that removes the liability of the vendor to pay the GST. It only works against, in the vendors, the property developers' favour, that they get a credit if it's paid. So, what happens if it isn't paid by the developer and it isn't paid by the purchaser? As I read the provision, there's nothing preventing the Commissioner from both requiring the purchaser to pay the amount he was liable to pay. You can just sue for the debt, issue the certificate, and also imposing the penalty of 100%. Now, I had a similar circumstance arise in an international tax case involving royalties called Task Technology, where this issue arose, and we tried to take the point, the Commissioner imposed the penalty, and we tried to take the point saying, well, this isn't a penalty case, it's a case involving the non-payment of the underlying liability, and the judges thought so much of my argument it isn't referred to in either the Justice Gordon's decision or the full court's decision. So, but it's a real issue because it just says there's a penalty, and it seems to me when it acts as a penalty, there's a penalty, and there's nothing to remove the liability. Now, there's some ameliorating provisions. Both are spectacularly unhelpful, I think. The first gives relief to a purchaser from the penalty if you don't withhold in response to a notice that says withholding doesn't apply or says you don't have to pay an amount. But you only get relief if there is nothing in the circumstances in the contract for the supply or any surrounding circumstance that made it unreasonable for you, the purchaser, to believe that the notice was right. In other words, you, the purchaser, can't rely on the notice that's been given to you by the vendor if you have reason to believe that it's wrong. This is going to set up a whole bunch of contractual fights, I can see it. And the other problem is, of course, when was it unreasonable for a consumer, not the registered person who has nothing to do with the GST, to have anything to know about what their withholding obligations are? And I can see a few negligence cases coming against solicitors, conveyancers who get it wrong. So it's something to watch very carefully, that if you're acting for a purchaser who's buying something that you suspect, have reason to believe is new residential property, you make inquiry. And I think the Act actually mandates that you pay the Commissioner even if there's a conflict with the vendor, and I suspect that's going to lead to some dispute. Now, there's another relieving provision which I think can be cleverly used by purchaser, because if you turn up with a bank cheque and the legislation doesn't require payment in cleared funds, it requires a bank cheque. So if you turn up with a bank cheque prior to the first consideration, excluding the deposit being paid, a bank cheque is provided, payable, the Commissioner is provided to the vendor, made out to the Commissioner for the amount payable, then you're relieved of your obligation. Presumably the bank cheque might be stolen by the purchaser. Now, what happens if the bank cheque bounces, I don't know. You seem to be relieved. Okay. Concerns for purchasers. First and foremost, a purchaser is liable to pay the withholding amount to the Commissioner whether or not you get notification from the vendor. Proposition 1. Proposition 2, you can't rely, if you're acting on the purchaser, to get out of your obligation to withhold. It's a matter that has to be determined by you. Let's hope your contract covers the circumstance. Secondly, there's no statutory mechanism or indemnity to set off against the vendor. So, to make the paper, that's going to lead to a position where you might have unscrupulous vendors using contracts that favour them that let you get out of it. Now, there is a provision for refunds. If amounts have been paid wrongly, so you've paid the Commissioner thinking it was to be withheld but you want to get refunded, but the refund application has to be made in approved form no later than 14 days before the day on which the GST is payable on the supply. In other words, you, the purchaser applying for the refund, need to know when the tax return is due, or for the period, by the vendor, In other words, to know when the timing for the obligation arises, and you're never going to know that. And it's a 14-day statutory limit with no room for extension. So I suspect a lot of dates are going to be missed. I would have thought if you missed the date and GST is paid twice, the purchaser would have a claim against the Commissioner for restitution for mistake of law, but then you're off to the federal court to pursue the Commissioner for small amounts or potentially small amounts. So that's a serious concern. And the fourth one, of course, I mentioned is the purchaser is exposed to penalties which are both financial and criminal. Now the main concern for vendors is that all vendors are required to notify subject to criminal sanction regardless of what these provisions have anything to do with them. So I think it should just become a standard term of every conveyance you send off a notice. Seems to me there's also going to be a big timing issue. The impact, particularly for geared developments, and I've acted for a few recently, very stressed geared developments with extremely high interest rates as they're trying to finish. As you sell the properties under this, if this regime applies to it, you're going to have at settlement 10% of the gross withheld, and you don't get the benefit of the money between settlement and the due date of your return as you do presently. And in the ones I'm talking about, that's some millions of dollars that would have been used to relieve the egregious interest rate being charged by the mezzanine funders. I mean, 30-40%. And it's going to create holes, and I've personally got some developments I think if these rules applied to would fall over if these rules applied. So it's going to have to be taken into account at the financing stage for developers, and anyone acting for distressed developers really has to pay close attention to it. And the final one, of course, is the property developers are going to run the prosecution gauntlet if they get their notices wrong. Having said all that, I've concluded by saying that in my paper that the amending act is lazy and disgraceful, and I think that it is, because the problem has nothing to do with anything but certain unscrupulous taxpayers, and could readily have been resolved by more targeted legislation rather than upending the universe for every lawyer and requiring a rewrite of how contracts work in the property sphere. For example, a director penalty notice regime exists for unpaid superannuation, unpaid PAYG. If it isn't paid on time by the company, the director is instantly personally liable. Why couldn't they have just added unpaid GST on new property sales to the DPN regime and made all the directors personally liable? I'm willing to bet that would stop 90% of it. And the out-and-out fraud, there's always going to be out-and-out fraud. What's happened is they brought in a regime that means the fraud will no longer be against the Commissioner, it will be focused upon the consumer. And the consumer is going to be in a less able position to do anything about it. They're going to end up out of pocket and without properties, and I think the whole regime should be withdrawn and they should start again because it's been completely stuffed up.
Thank you, Michael, for not mincing your words there. And we'll move on to David.
Thank you, Stephen. Now, ladies and gentlemen, or should I call you tax collectors, that's what some of you will be. My focus today is not so much on the legislation, but it's on the standard Law Institute, Real Estate Institute of Victoria co-published contract of sale of real estate. That now is to have a new special condition 5A headed GST withholding, and that's in your materials there. I do say in my paper that's recently published, it certainly was meant to be, but there are always glitches with these things, and its publication is imminent, if I may put it that way. But here you have a sample, and it's not, this is as it went off for publication. Now, before I'll say about this special condition 5A at the outset that it is not intended to replicate the legislative provisions. They speak for themselves. They stand for themselves. What it's designed to do is to complement, to build upon, to provide some contractual mechanisms that take into account the legislative requirements, but the wording is not necessarily exactly the same. Now, before I go there, just briefly to recap as to what this new regime is about. It's a GST withholding regime, as it's called. It's not a new tax. GST has been around for a while. It's a regime that, as you've heard said, obliges a purchaser of land, certain types of land, to make a payment to the Commissioner. It's an obligation to make that payment on account of the vendor's potential liability for GST, which might arise as a consequence of the sale. The obligation is to pay, is on the part of the purchaser to pay to the Commissioner an amount, and that's ordinarily 1/11 of the price, so it's about 9%, just over 9%, on receiving a taxable supply of a certain kind. And the payment is to be made when consideration for the supply, these are of course tax terms, tax legislation terms, not property law terms. Consideration means the price. Consideration for the supply, so that really means the price of the land, is first provided other than a deposit. So a deposit is carved out of this. So in the result, the payment is due on completion of the contract, or on settlement, if you want to put it that way. Now, in terms of application, this obligation arises, as I've said, on settlement of a contract to sale of land, and it's a settlement that occurs on or after 1 July this year. We're not quite there yet, but we're almost there. And that is the case whether the contract itself is entered into before or after that date. You could have a contract that's already been entered into. The exception I've referred to in the paper special treatment, it's really an exemption or exception, is where a contract, where when 1 July this year arrives, a contract has already been entered into. In that case, the payment obligation arises only where settlement occurs after 30 January 2020, so there's a 2-year lead-in period, if you like. Now that might sound a long way away, but 2 years goes fast, and obviously you're not looking at what we call cash contracts, you're looking at possibly a terms contract where payment can be spread over a number of years and final completion isn't due until the end of it. But more likely in this case you're talking about an off-the-plan sale, and where you can have settlement periods that can be 3, 4, 5, 6 years. So that's probably the most likely situation there. Excuse me a little bit. Now, so there are particular types of land that are involved. We have two expressions. Firstly, new residential premises. Now, premises is a familiar word in the landlord and tenant sphere, not so much in the sale of land context, but that's what the legislation, that's the term the legislation uses. And new residential premises will generally, well, a property will generally fall within that definition if it's residential and it's not previously been sold as a residential property. So it's a first-time sale. Also where there's a construction of a new building which replaces demolished premises, but substantial renovations are excluded, so they're not new. Where there's a substantial renovation, it doesn't result in new residential premises for the purposes of the tax legislation. As I understand it, I may be wrong, that's my reading of the legislation, but bear in mind I'm not a tax lawyer. Potential residential land is the other expression. Here you've got land and not premises, so, and you're talking about land that doesn't, unimproved land basically, whereas premises suggest that you're dealing with improved land. So here it's unimproved. It's land which is permissible to be used for residential purposes, and I would say that suggests residential zoning of some sort, but it does not contain any buildings which are residential premises. Now, not all potential residential land attracts the payment obligation, the purchaser's payment obligation, so it's only where the potential residential land is included in a plan of subdivision. The legislation says, uses a slightly different terminology, but that's clearly what it means. And there are some other circumstances in which the payment obligation doesn't arise, but I don't want to go into them. The amount I've dealt with, ordinarily 9%. If the margin scheme applies, then it's either 7 or perhaps 9. And purchaser's going to know whether or not the margin scheme applies because the particulars of sale in the contract will have the words margin scheme in a box, or they won't, one or the other. And there's some complex arrangements for reduced amounts where there's a mix of certain supplies, but I'm not, I don't want to go into that territory. So much for purchasers' obligations. Now you've got a vendor's obligation as well, which is to give a written GST withholding notice. Now that's to be given in the initial exposure draft of the legislation. It was supposed to be, legislation said it should be given at least 14 days before settlement, but the 14 days disappeared, so it's sometime before settlement. But when is another matter altogether. So, and that notice, as you've heard, has to state primarily whether or not there will be a payment obligation, and if yes, then various other information has to be given as well. Now that notice must be given by a vendor of any residential premises, not just new ones, any residential premises. The house that you live in, it's residential premises, it's a house. So there are going to be a lot of these notices that will be given, and a hell of a lot of them are going to say there'll be no, there's no requirement for the purchaser to make any payment under this legislation, and full stop. In addition, yes, so a vendor of potential residential land has the same obligation whether or not the land is included in a plan of subdivision. So it's a wider, the notification obligation attaching to a vendor is much wider than the actual payment obligation that attaches to a purchaser, if that makes sense. Withholding, well, withholding is a word that's used in this legislation, and was used in relation to foreign resident capital gains withholding, or FRCGW. Curiosity being that there is absolutely nothing in the legislation which obliges the purchaser to withhold at all. It's an obligation on the purchaser to pay, and the Commissioner doesn't care where you get the money from. You pay it out of your own pocket if you want to, but the legislation does allow the purchaser to, on my reading of the legislation, to deduct from the contract consideration, i.e. the sale price. There is a section in the Taxation Administration Act which allows that. I'll say no more about it, but it also, there is in the Special Condition itself, there is something to similar effect, which says the amount is to be deducted from the vendor's entitlement to the contract consideration. So there's the purchaser's entitlement, at least under the contract, to withhold. Payment, well, that's immediately after settlement. The Commissioner doesn't attend settlements. The purchaser can pay directly to the Commissioner after settlement. The Commissioner would expect to be fairly immediate. Could be made electronically on the day of settlement after settlement, or perhaps by a cheque being mailed, perhaps most likely a bank cheque, which would, as is usual with those sorts of payments that come out of what the vendor's entitlement at settlement, there'd be a bank cheque there, which, if it's a paper settlement, which would be shown to the vendor and then taken away. The legislation now, it didn't in the exposure draft, but it does now allow the purchaser to satisfy the purchaser's payment obligation by providing, not to the Commissioner, but surprisingly to the vendor at settlement, a bank cheque made out in favour of the Commissioner. An extraordinary state of affairs where the Commissioner is willing to take that risk, that the very vendors that the Commissioner is seeking to stop from avoiding or not paying tax is arming them with a cheque, and a bearer cheque at that. So anyway, that's the purchaser. I anticipate that unless you've got an electronic settlement, and I'll come to that in a moment, most purchasers will opt to satisfy their payment obligations to the Commissioner by handing to the vendor a bank cheque at settlement. Notification, well, if there's a direct payment, then there has to be a GST withholding purchaser payment notification form, etc., etc. There are some defences available to a purchaser who's under attack for failing to make the required payment. One is the situation where the bank cheque is provided, the bank cheque payable to the Commissioner but given to the vendor, and the other is where the purchaser receives from the vendor a GST withholding notice that I mentioned before. If the vendor gives one, the purchaser receives it, they can rely upon it, but with a proviso, a very important proviso, as long as there is no other information available to the purchaser which would make reliance on that notice unreasonable. Complex formula, but it says what it says. So, now we come to the most important part, which is this new Special Condition 5A for the standard, what I'll call the standard contract. How it operates, like many other special conditions, it operates by introducing a new general condition. Now, the general conditions can't be, I wish I could add to them with the stroke of a pen, but I can't, because the general conditions in the contract are prescribed. Part 2 of the contract, which contains the general conditions, is prescribed under the Estate Agents Act. And unless and until the Law Institute and the REIV decide to go back to the future and have a co-badged copyright contract like there used to be back in the 60s, I think it was, then the only way effectively general conditions can be modified is by way of special conditions. So we now have one hell of a patchwork quilt where there's almost as many pages of special conditions as there are general conditions. That's a matter for others, not me, to make decisions on. If I had my own way, it would be a copyright form of contract, and there would be no special conditions unless you wanted to add something yourself, which is truly what special conditions are meant to be. They're something special for a particular contract. Perhaps, obviously, for off-the-plan contracts, there will be many, but for most contracts, there might be something about a building inspection or pest inspection, although there's some optional general conditions for them now as well. Anyway, that explains why it's done as an insertion of a new general condition 15B, which is where it belongs in those general conditions. So but it's officially special condition 15A. Now, in the Law Soft version of this contract on the internet, it'll be slotted in between 5 and 6. There's a special condition 5, which I think is, don't hold me to this, I think it's FRCGW, and then 6 is something else. It'll be slotted in between them, but if you're using paper and you're buying from the Law Institute bookshop, or you already have a packet of 10, you can get this condition with sample stamped on it. When it's printed, it'll be one sheet of paper, 2 sides, and that'll be available. That can just be slotted into the contract wherever you think is appropriate to put it. So what does it say? We don't bother with definitions because there are many expressions that are used that are defined already in the Taxation Administration Act, or what I'll call the GST Act, and where we've used them, where they first appear in this general condition, they have an asterisk in front of them, just like in the tax legislation, but we haven't repeated the asterisk. So the condition itself, that's 15B1, 15B2, the condition is said to apply in 2 situations. One is if the purchaser is required to pay an amount because the property is either new residential premises or potential residential land, in either case falling within the parameters of the section, because there are some little tweaks to all of that. And secondly, this general condition is expressed to apply if the vendor has to give a GST withholding notice. And of course, both may be applicable. It may be either or both. But that's the condition applies in either situation or both. I've mentioned before about deduction. 15B3 very specifically allows the amount that the purchaser has to pay to be deducted from the contract consideration, and that means, the condition says whether or not the vendor has provided the GST withholding notice. And there's also, and obviously we're talking about, as I mentioned already, the deduction, the timing for the deduction will normally be at settlement, because that's when the purchaser's payment obligation under this legislation arises. Remember, it's not when the deposit is paid, it's when everything else is paid, everything but the deposit. There's a provision there also for the vendor to allow for such part of the amount as is represented by non-monetary consideration. So that might be where the contract provides for an exchange of property. That'll be a rare situation. Now we get to 15B 4, 5 and 6. Now, this is a very complex mechanism, but it is designed for a very specific purpose, and that is to ensure that where there is going to be money withheld, I'll use the term withheld in the loose sense, as in deducted, by the purchaser at settlement, it actually ends up in the Commissioner's hands. Because if it isn't paid, then the vendor still has no credit towards the vendor's GST liability to the Commissioner. So, and flipping the coin, if the purchaser doesn't, the other problem is if the purchaser doesn't pay, of course, then the purchaser is liable to pay a penalty to the Commissioner. And guess what? The penalty is the amount that should have been paid. It's the same as with FRCGW. So the idea, the concept is that the purchaser is obliged to engage either a legal practitioner or conveyancer, and we call that a representative, to conduct all aspects of settlement and performance of all the purchaser's obligations under not only the legislation but under this condition. And the idea being, of course, that it's a responsible third party, so someone that is subject to professional conduct regulation, and someone who has, more importantly, someone that has professional indemnity insurance. Now, the mechanism is quite elaborate. How often it will need to be resorted to is another matter, because obviously what doesn't apply if there's electronic conveyancing, I'll come to that in just a minute, and it won't apply either, there's no need for a representative to be appointed, blah, 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 if the mechanism of handing over a bank cheque to the vendor at settlement is followed. So maybe this representative won't be engaged all that very often. Electronic conveyancing, moving on, 15B6, allows for electronic settlement through PEXA or any other electronic system, because PEXA may have a competitor before too long. I'm not going to talk too much about PEXA or electronic conveyancing. There is another condition in the contract that covers electronic conveyancing. It's still an opt-in condition. I think it's number 8, if I remember rightly. Anyway, it's still opt-in. It's opt-in and opt-out. I'd prefer to have it opt-out, but people would be very brave to ignore electronic conveyancing. It's really electronic completion, but anyway, it's called electronic conveyancing because it won't be too long before paper forms won't be accepted at the Land Titles Office. A lot of them are being phased out already. It won't be too long before all of them are phased out, except for paper documents that are already executed. So the PEXA system, in short, allows for this payment to be made to the Commissioner, and also for FRCGW withholding amounts to be paid as well. Bank cheque, that's 15B7, that covers the bank cheque scenario that I've mentioned at least more than once. But the condition goes on to say that where that procedure is, well, I'll make 2 points about it. Firstly, it does require the vendor to agree to that method. I can't imagine why the vendor wouldn't, but it does require the vendor to acquiesce in the bank cheque being handed over, because I suppose it puts the responsibility on the vendor to deal with it. Maybe a vendor is happier with the purchaser making the payment directly to the Commissioner. Also, the vendor is then obliged by this contract condition to give the purchaser a receipt for the bank cheque, which identifies the transaction and has in the receipt particulars of the cheque relevant particulars. So, and also there's an obligation on the vendor to immediately after settlement provide the bank cheque to the Commissioner. I can't imagine why the vendor wouldn't, but anyway, if they've, well, I can imagine many instances why the vendor wouldn't, as my colleague Bearman has explained, but anyway, that's precisely the problem that the Commissioner is trying to address with this legislation. 15B8 is designed to assist a purchaser to make payment, which I gather requires some prescribed form that might be styled GST withholding purchaser payment notification. That's the intention of 15B8, but it might also prompt, might elicit the GST withholding notice from the vendor. It might encompass that. I'm not saying it will. It's just occurred to me as recently as tonight that it might. If that GST withholding notice has not been forthcoming within a reasonable time before settlement, then the purchaser might rely upon 15B8 to say, well, you give me the following information, and then set out all the information that should be supplied. Finally, vendor warranties. There's two warranties. The first applies where the vendor has given the GST withholding notice and has given the notice which says no payment required, or fails to give the written notice at all. And the second warranty is to the effect that where the notice specifies an amount as payable, that is the correct amount. Penalties, there's 15B10 just reminds the purchaser that they're really responsible for penalties or interest payable for non-payment or late payment, but there are exceptions there where there's some failure on the part of the vendor. And we've said also that if in that case, if the exceptions apply, then the vendor is the one liable for the penalties and interest. So that provides a mechanism for enforcement by a purchaser against a vendor if it comes to that. Now, I'll just finish off. I want to allow some time for questions. If they're difficult questions, address them to Bearman. I'll deal with the easy ones. Two further matters. Firstly, this regime operates alongside FRCGW. So, conceivably, you could have two deductions at settlement. The vendor the transaction might be caught by both regimes. And if that's the case, the mathematics is interesting because FRCGW is now 12.5%, and this, we're talking about a 90%, say there's a 10% deposit, we're talking about 90% available at settlement, 12.5% for FRCGW and about 9% for GSTW. There may not be, out of the 90%, you might end up with 78.5 left to pay out mortgages and other securities. So if the vendor's highly geared, this could cause some real problems. And a related issue is this. My favourite topic being the Sale of Land Act. Well, Section 27, as we all know, deals with deposit releases, early deposit releases. Of course, that well predates all of these new tax regimes, so it doesn't accommodate them, makes no allowance for them. So the purchaser, I suggest, can't legitimately refuse a deposit release, and I'm using the terms fairly loosely, if they believe that the balance at settlement, the 90% balance, may, after taking out withholding, one or two withholding amounts, may be insufficient to pay out mortgages. I don't believe that that's within the purview within the ambit of Section 27. Maybe that section will be changed at some point, but the way it reads at the moment, those amounts cannot be properly factored into account. So, I've left 5 minutes for questions. Thank you.
Thank you, David.
I have a quick correction. I sort of went a bit too far in my zeal. As David's pointed out, and Stephen's reminded me of the section, where there is a requirement to withhold under Section 14, Section 16, and it's withheld, Section 16.20 removes the obligation to pay the vendor. I think I said that there was no provision. There is a provision, but it only applies, which is what I was trying to say, that if there is in fact a requirement to withhold. So if Division 14 doesn't apply, then there's no statutory mechanism that picks it up. And the second point I want to make about that is that it doesn't pick up the fact if you don't and you get penalised, because the penalty is in fact not the payment of the withholding amount. So you can end up with these double amounts. I think I just overstated it when I was...
Right. Thank you, Michael. We've got time for questions and comments, so would someone like to start us off?
Well, if there aren't any, or is people still thinking about it?
We have a gentleman in the centre.
Just to make it very simple for simple solicitors like me, what should be a simple procedure that perhaps, something for dummies, do this, do that, what procedures should we follow? If there is any.
I'll leave that to better qualified people such as Russell Cox. I suspect you'll see something from Rusty in the Law Institute Journal in the very near future, or LPLC has a column there. There'll be something that there'll be some guidance there. Well, there's certainly, I shouldn't say there will be. There certainly should be some guidance, but I can't speak for the Law Institute of Victoria. I'm afraid these are complex concepts, and there's really no way to put it. I've tried in my paper to put it as simply as possible. I might just correct something in there, make two corrections if I may. If you have the papers in front of you, about halfway down the front page, it says legislative provisions as the heading. Go to line 3, where it says a few words in subsection 3, it should be subsection 4. Pedantic, but it should say subsection 4. And if you want the paper to read accurately. And secondly, flip the page down the bottom, the paragraph headed vendor's notice. Go down to the end of the third line and rule through at least 14 days before settlement. I think I mentioned that when I was speaking. Rule that through. So rule through at least. Settlement. Yes. Oh, sorry. Rule out at least 14 days. Yeah. Leave the words at before settlement. So it couldn't be at settlement.
Well, it can be at settlement. It can be immediately prior to.
Immediately prior. Yes, 5 minutes before.
Yeah.
I think in practice, I'd be very surprised if vendors were a bit more careful with this. I mean, it's in the vendor's interest to give the notice. Otherwise, the vendor is at the mercy of the purchaser as to what's deducted. Sorry.
So the answer is the LIV is going to say something about this, or?
The answer is the LIV should be offering. I mean, its role is to, one of its many roles is to offer guidance to practitioners, and it should be taking the lead here. I've done my part by writing the contract. There was an article in the Journal a couple of months ago about this very topic and the contract itself. Unfortunately, that was based when that was written by me and Murray McCutcheon. Unfortunately, we drew that when we were writing the article. We were relying fairly heavily on the exposure draft of the legislation, and there were some changes that were made to the final version, but editorial deadlines didn't make it feasible or didn't allow for corrections to be made in time. It's just the way it is, but there'll be a further article published in the next few months which will be right. Well, actually it'll be pretty much what's said here, so you probably don't need to read it.
The reality is, in the short term, if you have a large client base concerning property development, residential property development, you need to get on top of this fairly quickly, because you're going to have standard processes in place. You've got a little bit of time. If you're acting for purchases, this is really, in a realistic context, going to kick in for contracts after 1 July 2018. At which point, I think the real process in the office of the people doing the work is to be identifying purchases that are of new residential property and having a means of distinguishing it from any other conveyance, because you immediately want to pick it up. Now, I don't know what the processes have been for the foreign withholding tax, but it seemed to me the two sort of run hand in hand It's a question for instructions that must be obtained, and I think they're the two most immediate things. And then the next big phase for everybody will when the first round of settlements comes through where these provisions apply, and hopefully by then the powers that be will have promulgated some rules. There's an explanatory memorandum to the tax legislation which I think really misunderstands how conveyancing practice works. I don't think the tax office turned their mind to any of this. For example, there's an assumption in the legislation that both parties have access to all information about each other, and it's just craziness.
That's true. That actually reminds me, what you just said reminded me of one other thing, that there is one significant difference, well, there are many differences, but one stands out between this regime and the FRCGW regime. In the case of the latter, the purchaser can rely safely on a clearance certificate that the vendor gets from the Commissioner. People get these clearance certificates. You can get them just a click of a finger. Now, I think you get them for free anyway. So in 90% or 9 out of 10 cases, no doubt, there is that clearance certificate and the purchaser can rely upon it safely. Not so here. There's no clearance certificate from the Commissioner here whatsoever.
Another question or comment?
We must have done our job. Oh, there's one. Doing our job very well. No.
My name is Grace. So I just have a simple question about the 15B.3 of the amended special condition.
Yes.
So it's saying that the purchaser is obligated to withhold whether or not the vendor provides the purchaser with the GST withholding notice.
More correctly, the purchaser can withhold.
Can withhold.
Yes, the purchaser can withhold.
Okay, so
Can by means of, and when I say withhold, I mean by means of deducting.
Yeah.
That's making a deduction at settlement.
Okay, so if I understand it correctly, so at the settlement, purchaser will can withhold an amount and it will make a check payable to the Commissioner, and then provide that check to the vendor, and it's the vendor's liberty to whether provide that to the Commissioner. Is that how it
yes,
works?
well, the vendor's supposed to, but the purchaser is exculpated by giving that bank cheque at settlement for an amount that is payable to the Commissioner.
Okay, and
So it's like if you've got unpaid rates. It's exactly the same mechanism. Unpaid rates. There will be a cheque payable to the local council, and it's deducted. It comes off in the settlement statement.
Yeah. So my question is, what is the point of the withholding notice? Like the notice of declaring whether this is a new property or not?
That's a really good question. The way the legislation is drafted, the purpose of it is to make the vendor make the declaration at risk of criminal conviction if they don't, but it's got no consequences at all, doesn't assist the purchaser in any way, and the purchaser has to make its own inquiries.
Yes, although there is one of the defences that I mentioned does, but it's not straightforward. It's only where where there was nothing that the purchaser had available, no information the purchaser had available, which wouldn't make reliance on the notice unreasonable. It's very complicated.
The real problem is whether or not the notice is given, the purchaser has the liability to pay if it's new residential property, and the question is apt because you're given no protection by the notice.
Yeah.
Is it? Yeah.
Yes. So if the vendor considers that it doesn't fall within the scope of withholding and issues a null notice saying, here's your notice, the amount is zero, but they are in fact wrong, then it's up to the purchaser to figure out that they are wrong and to withhold. And if they don't, they're prima facie subject to a penalty, and they've got to argue that they fall within an exculpatory defence.
Well, no, the exculpatory defence doesn't apply to the penalty for the Tax Administration Act. They're still liable for the tax penalty. It only exculpates them from the criminal offence.
Oh.
So the tax penalty is there. If you get it wrong as the purchaser, you're running the gauntlet, because you will be liable, and potentially, depending on how you read the Act, you're liable twice. So it's
but
scary.
it may not be, let me just chime in by saying, it may not be that hard for a purchaser. If you're buying an off-the-plan apartment in Docklands, it's pretty obvious that it's new residential premises.
So it's not so much the purchaser, it's the processes for for the solicitors and the conveyancers dealing with it to know that they have a purchaser who's got in these circumstances. Make sure you get the instruction. That's the critical factor, because once you're told you're buying off the plan, or it's a greenfields development, or there's a new apartment block on up, once you've got that instruction, you acting for the purchaser know.
Yeah, but the GST be withheld on a property which has been principal place of residence and being sold for the first time. So, for example, the residential premises was built 10 years ago.
No is the answer unless it's been demolished to a new site. So if you're owning, if there's an owner of a residential premises, I own my home, I sell my home, even if I renovate it before I sell it, it's new residential premises, there may be GST, but there's not going to be withholding. And that's the distinction.
My question is, if you've got a situation where there isn't an enterprise, right, but it's still a new residential property.
Trick question.
What happens there?
Okay, so the question is, what happens if there isn't an enterprise but it's new residential property? There will be an enterprise usually, because an enterprise can include a single adventure in the nature of trade, and it will be over the threshold of 75,000 because the value of the property is going to be over 75,000. So the mere fact that you're not registered doesn't mean you aren't required to be registered. So in those circumstances, if you've got a one-off and you're doing it for profit, you're not just doing up your house before you sell it, but you've got an investment property, a couple of blocks, and you're going to turn them into something, then you're going to have to register and bring yourself within the regime.
And presumably the purchaser will...
And then it flows to the purchaser. If you're not registered, then I don't think there could ever be withholding, because there's no GST. But again, this legislation doesn't deal with that. It makes you liable, presumably, for the defaults of the vendor who's committed a criminal offence in those circumstances. But it doesn't ameliorate the liability of the purchaser to pay over the amount. Yeah.
So I've got a question. So this doesn't apply to commercial properties that are plus GST, it's just residential?
Yeah, it's only new residential. It doesn't apply to commercial, and it doesn't apply to what's called commercial residential, which is if you've got, it's defined in the Act, but it's inns, hotels, hostels, school accommodation, those sorts of things are treated as commercial property for these purposes, even though they're residences. Another one there. Sorry.
What is the penalty for a vendor failing to give the notice to the purchaser?
It's a criminal offence. 100 penalty units. Another one here.
Sorry, I ended up with the microphone. If I can go ahead and
It's a
sir.
strict liability criminal.
Given the concerns you've raised with the legislation, what's the likelihood it may ever be changed and improved to pick up the kinds of concerns you have?
I suspect it will be improved in due course as it begins to suffer in practice. I imagine there'll be bits and bobs. I can't imagine the bank check exemption sitting there forever in its current form. I mean, surely you should be relieved by, the mere payment of the commissioner should be enough to relieve you of everything. There also needs to be more mechanisms to fix things up if people get it wrong. I mean, 14-day notice period is just ridiculous.
So even if the vendor says, I'm not registered, the purchaser has to second guess him?
Yeah, because if it's new residential property, they're almost always going to have to be registered. I mean, I don't know how it applies. I mean, if you're just buying a block of land and it's potential residential property, I don't know how that's going to work.
But it has to be it doesn't have to be new residential plan that's subject to a plan of subdivision.
Yeah, that's right. Yeah, that's right. Yeah.
It just can't be an odd block.
It can't be an odd block, but if there's a plan of subdivision in place, you subdivide off your backyard and sell it. It's going to be very difficult.
I remember a few years back, there were quite a few home office developments, people selling off the plan, I think especially at Beacon Cove, where it would be a triple storey and it would be commercial with residential. You mentioned hotels, a lot of other things, but if people were to go down that path, I mean, how would you, the fact that it's got both commercial and residential, how would that be treated?
The legislation allows for apportionment if there's more than one part of the sale. So if it's, I think it'd have to be two titles that have got sold as part of a single strata title. Sorry, my microphone. If you had two titles, for example, it gets apportioned.
No, it was on one title.
On one title.
They did that at Beacon Cove.
Well, if it's a true home office, it would be just new residential property. It wouldn't be commercial. Yeah. one just behind you.
I don't know about the rest of my colleagues here, but my conveyancing fees are very reasonable. How do we educate the public to expect to pay more, given all the extras we've had to do over the last couple of years, register, learn PEXA, etc., etc.?
Well, I think you have to add disbursements for counsel's advice, of course.
Yeah, it's just not valued. Yeah.
David, sorry, when we talk about the notice from the vendor, why is there not a warranty in the contract by the vendor as to whether it is new or whether the Act applies?
Well, there is. It's in 15B9.
So is that adequate notice, or does the vendor still have to give notice?
It's not a notice for the purposes.
Well, there's a warranty there.
It won't be notice for the purposes of the Act.
Oh, I see, yeah.
Yeah, it wouldn't be a notice for the purposes of the Act is the answer, because there's specified requirements as to what the notice must contain.
So not worth putting something in the contract which says for the purposes of the Act, this is a notice I'm supposed to give you?
Well, the legislation is very specific as to what the notice must contain and the form it has to be in. It's not for the contract to spell that out. That's what I was saying at the very outset. We're not intending to replicate the provisions of the legislation. We're simply complementing them in the best we can. Just about that.
Put another way, the legislation assumes contractual arrangements that require it to work, and what the contract does is it allows the legislation to work in the format of the contract, but it doesn't fulfil all your your legislative requirements. For example, there are notification provisions and the like, and not to mention the lodging of the GST return or the claiming of the refund and the like, that simply aren't relevant as between contracting parties. They're just tax obligations imposed on vendors and purchasers.
Yes, and one of the parameters of the contract has always been not to be too prescriptive, but so this contract does not spell out everything that a vendor must do, and the number of days within it must, the number of days within which the vendor must do something, and likewise the purchaser. It's not designed to be overly prescriptive, unlike some other states. So there.
Okay. If we might just thank our two speakers in the usual manner.